Hello, everyone. My name is Letitia Wilson. I am a doctoral student at North Central University. I am going to be speaking with you in regards to an assignment I have for one of my classes, where we are to discuss the legal and ethical roles of the marriage and family therapist in regards to divorce proceedings. I am also going to explain what those proceedings look like in the terms that the clients can understand, as well as what custody is, because so often you're unaware of what you're getting into. And if I was talking to a client or a family that I had that were getting ready to go through these types of procedures, I would want them to understand as simply as possible what they will be facing so that they would be prepared and can make the best decisions possible for themselves. So, I first want to let you know that divorce proceedings vary from state to state, and you have a general process, but because each state is different, each the rules, the laws, and regulations in regards to it, the ethical guidelines kind of vary from state to state. Therefore, even though I'm giving you this presentation, and it will be heavily based on the state of Texas, since that's where I will be doing my practice primarily, you should be sure to look at the laws applicable to you in the state in which you would be practicing to get a more specific guide on how these proceedings work so that you can best articulate this to your clients in a way that they can understand it. So first, I want to give a general overview of the divorce process. And just to be completely honest, the cost and the duration and the difficulty of the divorce has a lot to do with the amicability of the partners that are coming into the divorce proceedings, how well the spouses can come to mutual agreement before the proceedings kind of get started will be very, very important. So, just to let you know who the parties are in the divorce proceedings, that's the first thing that has to be identified. The spouse that files the petition for divorce is known as the petitioner. This is the person who initiates divorce with the court, and the other spouse is known as the respondent. And then it's important to know the jurisdiction. So, for the state of Texas, the divorces can only be granted to Texas residents. That means that at least one of the spouses has to have resided in the state of Texas 6 months prior to the petition for divorce being filed. As far as the venue, they must reside in a specific county at least 90 days before filing for that particular county where the divorce will be done. And it's also important to note that Texas is a no-fault divorce state. And this means that one spouse does not have to prove that the other spouse has done anything wrong in order to obtain a divorce. You cannot be held in a marriage if the other spouse does not want to sign or refuses to participate in the divorce proceedings. Oftentimes, you'll find in some states where a person will file for divorce, the other person doesn't want it or heavily contest it, and so the proceeding drags on for long periods of time, almost locking this person, the petitioner, into a marriage that they no longer wants to participate in. Well, that is not the case here in Texas. It's a no-fault state. It can get costly and lengthy because of the couple's inability to agree. However, if there comes a point where they just absolutely can't agree, the courts will intervene, and you will have the court come in and make decisions on how to divide the assets if you cannot come to an amicable agreement. Also, in the state of Texas, you have the what's called the cooling off period, or where the state cannot grant a divorce until 61 days have passed from the date the petition was filed. And this is to, kind of give you time to make sure that this is what you want to do, that you don't want to change your mind. So they call it the cooling off period. And I think this is important. This gives you an opportunity, especially if you're seeking counsel or a counselor or a therapist, to kind of help you work through those thoughts, to make sure that this is what I want to do, to make sure this is in my best interest. It's also a time to kind of help you come to some mediation and resolutions if it is something you've said that this is certainly what I want to do, kind of to help you cool off any anger or resentment that you may have that can hinder the process of coming to resolutions as far as what you own and the children involved. After the divorce decree is signed by the judge, each spouse can technically file an appeal for 30 days. As such, neither spouse can go and enter into another marriage until the divorce decree is final and the 30 days has lapsed. So, you can't divorce one day, is signed, and then the next day you go and get another marriage started. Then the grounds for divorce in the state of Texas are adultery, abandonment, confinement for incurable insanity for 3 years, conviction of a felony, and imprisonment for over 1 year, meaning that you have a spouse that is incarcerated and you no longer want to remain in the marriage, or if you're in cruel and inhumane treatment, so in an abusive relationship, that is grounds for divorce. And supportability, you have this, it's very high, especially in the state of Texas where I'm located. You find that very high around military installations, especially with the deployment. The spouse is left, no funds, and not being properly taken care of or getting the things they need to properly take care of themselves. And then it also constitutes discord or conflict of personalities that has prevented any reasonable expectation of reconciliation. We just not compatible. And it's not going to work. And even though we've had this time of remediation, we've had this time to cool off, nothing's changed because we've been married X amount of time and it hasn't changed. Next is, what is child custody? So often the clients are not aware of what custody entails, and they feel like, man, I have to have custody because this means I'm losing my rights, I'm losing my children. And custody is very, very, very important part of the divorce proceedings because you have the children involved who are not responsible for what's going on, and they can be greatly affected by this process. Their lives are being changed. They're being taken into different homes, possibly going to be in blended families going forward. So it's very important to be able to come to some resolutions with it. So even if your spouse are never on the same page with money, it is so important to come to an agreement with custody. A child custody fight will indeed harm the child more than any other kind of dispute that might come up in the divorce, proceedings. At all costs, try anything to avoid, having that battle out over the children. Things you have to figure out is if you have children, you or your spouse will have to pay child support. You have to decide whether you or your spouse will share custody equally, or will you have primary custody, or, vice versa. The person who does not have custody will be awarded visitation rights. That is a right you have, as long as it's not a detriment to the child. And most times you're not able to use the kids as a pawn to get what you want, because most times it's going to be harmful to the children. So you have to be able to come to that agreement. You have the person that does not have custody does have a right to get visitations, and it has to be reasonable visitations, and it's court ordered and it's court mandated, and it is a legal binding document once it's court ordered. Both spouses or one spouse may be ordered to make either periodic lump sum or in some cases pay both payment intervals to take care of the child. There are different types of custody. Custody means to have physical custody. Your child lives with you, and legal custody, you're able to make legal decisions and about the child's welfare and education. Sole custody, if a parent has both legal and physical custody and the other has fairly limited visitation, this is called sole custody, meaning I make all of the decisions, or that parent rather makes all of the decisions for that child. This one right here, like I say, the visitation has strict limitations on it. Joint custody, however, both parents share physical and legal custody of that child, meaning we both make decisions. We both play a part and a huge role in this child's life. And moving right along, we'll talk about the considerations for evaluating child custody arrangements or mental health of a caregiver. Now, this comes down to the mental health provider. It is very, very important that you not go into this with a bias or prejudgments or prejudices, because there's a child involved, and whatever you do in this regard, it's about making sure that things are in the best interest of the child. It's a very important task, and it should be carefully and diligently considered before even participating in it. You can even seek input from other counselors or supervisor or whomever you consult with as a therapist to make sure that I am prepared, I have the education, I have the knowledge and the wherewithal to adequately participate in an evaluation of this family. And you want to make sure that you do a fair and appropriate evaluation, and you want to make sure that all the legal and ethical parameters of the state are followed and adhered to before taking on the task. You want to be able to be prepared for it. Also, you want to know the possible consequences, because you're going to be making an evaluation that's going to come into some play on your best judgment. And if you are not prepared or adequately equipped to do so, it can affect your license. If it's deemed to be harmful, if it's deemed to be prejudicial towards one parent or the other. And as I just alluded to before, agreeing to conduct an evaluation as a therapist, again, make sure you are educationally competent, capable of doing so, that you are able to provide sound, unbiased judgment and evaluations based on the information obtained from all parties, not one side over the other. You're trying to make a thorough evaluation based on the best needs of the child, based on the information that you're given. And you want to make sure that the evaluation is appropriate to what is being asked by the courts. You want to make sure that informed consents, everyone participating is aware of what is being evaluated, what is the consequences of the evaluation, what is the purpose. You don't want to come with any false pretenses or leave anything up in the air and come with any ambiguity. I'm so sorry about that. I got tongue-tied. But you want to make sure that you're clear and concise in what you're doing. Okay? Moving right along. The AMFT Code of Ethics considerations. As a therapist, we have a code of ethics to follow. So if I have to testify in legal proceedings, the Code of Ethics state that marriage and family therapists who provide expert or fact witness testimony in legal proceedings avoid misleading judgments based conclusions and opinions on appropriate data, and avoid inaccuracies insofar as possible. When offering testimony as marriage and family therapists, experts, they shall strive to be accurate, objective, fair, and independent. And as I just stated, you want to make sure that what you're saying is clear, concise, and accurate, and it's based on facts. It's not based on opinions and consumptions. And you want to make sure you're competent. You want to make sure that you have a clear separation from custody evaluation versus therapy. When you're doing an evaluation, it's just that, an evaluation. It's not a therapy. I'm not coming in to fix and repair anything. I'm doing an evaluation based upon the information I have, based upon the information that is provided in the information tool or system I am using, based on what the court is asking and requiring. You don't want to go outside of those parameters. You don't want to come up with your own thing. You don't want to start digging and making up things. And then we're going to move to tips for releasing information when subpoenaed. It is critical that therapists understand that they must always provide some response to a subpoena. You don't want to just say, oh, I got the subpoena and I'm not going to do it. You want to provide a response, even if it's to make sure that you go and check with legal to make sure that whether or not it's in the best interest of my client to respond, how I need to respond, am I legally required to respond, or do I have a legal option to decline to respond if it should deem that it's going to hurt my client. The response must be in writing and must be sent to all parties in the case. The response must be received by the requester in the time allotted on the subpoena. It is also very, very important that you determine the laws required and that you're clear about what is being asked and stick with what is being asked. Don't try to go and make up your own things. Don't try and be overly informative, but make sure that it's clear and concise if and when it is said that you are. And you want to make sure that you contact the individuals involved whose information you will be providing. Make sure you know the legal laws, that you contact counsel and you are giving contact your lawyer or whoever your legal personnel is to make sure what are my requirements in this case. We are therapists. We're not lawyers, and we have legal insurance for a reason, because we want to utilize that and make sure that we're operating within the confines of the law at all time, but as well in the best interest of our clients and the families we serve. Thank you. I really hope this has been helpful for you, and I hope to be able to speak with you again. Have a blessed one.